We are on to the fifth and final essay on the California bar exam in February 2023. Visualize yourself in the bar exam. This is Tuesday afternoon. It's the second hour under standard testing conditions, and you have exactly 1 hour before you should be starting the performance test. Let's figure out what the subject is. So I look down at the bottom of the page and I see that the question continues on the next page, but the first call says the photocopy of the advertisement. So I look just above that and see, assuming all proper objections and motions to strike were timely made, should the court have admitted that copy of the advertisement? So this is pure evidence. I turn the page and see call 2, Pedro's testimony about the value of the painting. P name, that's going to be the plaintiff. Call 3, Rex's testimony about the age of the painting. Maybe an expert witness. Call 4, the excerpt from The Science of Dating Works of Art. And call 5, Rex's journal article. And then the further instruction, answer according to the federal rules of evidence. Very interesting. Rex has already been a testifying witness, and in call 5 we have Rex's journal article. So I wonder if this is either impeachment or rehabilitation of this witness. But before we get any further into this is evidence. It's got 5 calls. Evidence, fact patterns are always tremendous racehorses. I have to finish this in an hour. I can't shortchange myself on the time for the performance test. There are going to be a lot of issues, and evidence for me personally is one of the more difficult subjects to get through, to keep all of the elements of all of the hearsay exceptions, exemptions, exclusions in mind, and all of the detail of the subject. So I need an analysis strategy. I need a plan. I need to know what I should be thinking about at every stage of this. So let's stop and take a look at what my analysis strategy is. Yours may differ, but you really have to have one in order to get through one of these evidence essays. We're in federal evidence, and I have an analytic approach that I use when I try to answer evidence essays. I have 7 basic steps, 7 things I'm thinking about, asking myself for every single piece of evidence they ask me about. Is it logically relevant, and why? Can we find a policy to keep it out even if it's logically relevant? That's the issue of legal relevance. Can we keep it out because of prejudicial impact, Rule 403? Does it involve character evidence? Does it involve witnesses or documents? Because there are separate issues if there are witnesses or if it's a document. Is it hearsay? And does it involve a privilege? Those are in my mind for every piece of evidence. And now back to the hypothetical. We're given Pedro, who brought a fraud and breach of contract action against Gallery in federal court. At a jury trial, Pedro testified that he purchased a painting from Gallery for $200,000 after seeing an advertisement bearing Gallery's logo stating that the painting was the only painting by a noted 17th century artist available for sale in the world. So we have a civil case, we have the plaintiff's case in chief going on right here. On Pedro's motion, a photocopy of the advertisement was admitted into evidence. A photocopy of a document. We have the best evidence rule at issue here. Pedro also testified that the painting was worth only $10,000 because it was a reproduction of the original, and that he based his valuation on the average of 3 appraisals of the painting by art dealers. Issue 1, call 1, the photocopy of the advertisement. That's what's going on here. Start with logical relevance and probably also legal relevance here. And as I said, we need to worry about the best evidence rule. So let's take a look at our schema and see what it gives us. What do I worry about with a document? Well, I have several issues I need to think about. I need to establish its relevance. It needs to be authenticated. It needs to be in compliance with the best evidence rule. It needs to be non-hearsay or exempted, accepted from the hearsay rule. And it needs to be non-privileged in order to admit it. Now, as to the best evidence rule, a photocopy is okay, unless there's some question as to authenticity. The contents would be at issue here, so hearsay is an issue, because he bought the painting for $200,000 after seeing the contents of this ad. Okay, the rest of the paragraph is about the basis for his assertion that the painting is really only worth $10,000. And he discusses the 3 appraisals of the painting that he got from appraisers. That's call 2. We have a witness on the stand. What are the issues here? With a witness, I need to establish competence, at least the first time I get a witness, and I want to think about impeachment. Here, Pedro is the first witness I'm given. Impeachment is not an issue. He's discussing what he learned from 3 people outside this proceeding. So I would think that hearsay is a big issue here. And how are we going to get this in? That brings us to the hardest part about memorizing evidence before the bar exam, and that is memorizing the details, the elements for all of the hearsay exclusions, exemptions, and exceptions. So let's go back to the main part of the schema, to the hearsay rule. Everyone knows the rule itself. The hard part is memorizing the exclusions, the exemptions, and the exceptions, and all the detail that goes into each of those. There you see the exclusions. The exemptions include prior statements and admissions. Prior statements include prior inconsistent statements. And it looks to me like we probably have one of those in this hypothetical because of this second thing about Rex. Then we have all of the exceptions. And I have to group these into smaller groupings because the span of apprehension is normally 5 to 7 things at a time, and there are too many exceptions for me to memorize the whole list at once. So I group them into the unavailability type, the reliability type, the documentary type, and others. And you'll see that on the screen. I'm not going to torture you with all the detail that unfolds from there. But all of that has to be memorized before you walk into that bar exam. So if I'm thinking that Pedro is discussing something he heard out of court or saw out of court, but in any case an out-of-court statement by 3 different appraisers, what do I do with that? I would think that that would be hearsay. As I record this, we don't yet have selected answers from the bar, so I don't know what they wanted here. But I would analyze this as hearsay, and I think I would probably use business record to get this in. Also try one other way to get around that hearsay rule, because this is an issue spotting exam. So calls 1 and 2 in the first paragraph. Then we get Pedro called Rex, a chemistry professor who had been retained by 4 art galleries to determine the age of paintings. So Rex is being called as an expert witness. What do we need to worry about expert witnesses? Back to the schema and how evidence is being presented. Here we have an opinion about to be delivered, an expert witness opinion. Opinions from expert witnesses are admissible as long as, and here we have the requirements, the testimony assists the fact finder, the expert is qualified, the opinion is within the expert's scope of expertise, and it's based on evidence reasonably relied on by experts in that field. So those are the facts I expect to see in the rest of this paragraph. We know that Rex is a chemistry professor, so he's an expert in chemistry. Does that make him qualified to talk about the age of paintings? Is this within the scope of his expertise? That's a question for me. So go on with the hypothetical. Rex testified that the painting had been painted within the past 50 years and was a painted reproduction of the original painting. He testified that he had used the XYZ technique on Pedro's painting to arrive at his conclusion. Rex testified that he had tested the XYZ technique on paintings of known ages and that the results corresponded with their known age. He testified that the XYZ technique was reliable and used by most experts to determine the age of paintings. After cross-examination, Rex was excused and left the courtroom. Okay, now your problem is analyzing whether that testimony was within the scope of his expertise and whether that was the sort of technique, the sort of information relied on by most experts in that field. And I think the conclusion you draw is less important than the fact that you analyze all that. Now, Gallery calls Marie. Both parties stipulated that she is an expert on dating works of art. She testified that a publication entitled The Science of Dating Works of Art is generally recognized as a reliable authority. She then quoted an excerpt from that publication that asserted the XYZ technique is not reliable for determining the age of works of art. Gallery moved and the court received the excerpt into evidence as an exhibit. A ton of issues raised by that paragraph. This is after Rex had already been cross-examined and had left the courtroom, and now Gallery, the defendant, is offering evidence. So we're in the defendant's case now, and they've brought their expert in. You don't have to go through great detail about the requirements for an expert witness again, because you already showed the grader that you know how to do that when you talked about Rex. Both sides stipulated that she's an expert. She's testifying about a publication, an out-of-court statement. And she quotes an excerpt from that out-of-court statement. So we have hearsay here, right? And we probably have a learned treatise exception to the hearsay rule. An expert does not have to admit into evidence the treatise they're relying on, but here they do. And all we're asked is whether it was proper to admit that excerpt into evidence. So the hearsay rule about learned treatises is that to the extent that she relied on the statements in that published treatise, those statements are admissible and they can be read into evidence as long as the expert has testified as to their authoritativeness. They gave us that fact here. But they may not be received as exhibits. So it was improper to receive the excerpt as an exhibit into evidence. Calbar has tested this more than once. It's really nitpicky detail, isn't it? That was call 4, and if you knew that rule really well, that was a very straightforward thing to answer. You could do that call pretty quickly. So what do we have next? Gallery then offered into evidence a journal article authored by Rex that included a statement that the XYZ technique is not reliable for determining the age of works of art. This is an out-of-court statement. Is it being offered for its truth? I don't think so. I think it's being offered to impeach. We have 5 ways to impeach a witness. Character for truth and veracity, that's not what's going on here. Bias or motive, no. Prior inconsistent statement. That's non-hearsay. Now, if you're offering this statement for its truth, then it has to be under oath and the declarant has to be subject to cross. So this can't come in for its truth, because when Rex made the prior statement, he was not under oath, he's not now here, and he's not subject to cross. He left the court. But simply as a prior inconsistent statement, it is admissible to try to prove to the jury that they cannot believe what Rex said under oath. And of course, the other ways to impeach are to prove a defect in memory, perception, or knowledge, not an issue here, or conviction of a crime, which is also not an issue here. So this is a prior inconsistent statement. And as I said, its admissibility hinges on whether gallery is trying to prove that XYZ technique is not a reliable technique, or whether they're simply trying to impugn Rex's credibility. 5 calls, an absolute racehorse. You cannot do the level of analysis you would have done on a law school evidence exam. You have to get in there and get out as quickly as you can, because you need to finish all 5 calls and spot as many issues as possible. I would not worry about legal relevance more than one time to show the reader that you know about it, unless, of course, it becomes a main issue in one of the calls in an evidence hypothetical. These are tough. It's tough to keep yourself down to the time you're supposed to spend on this, but you really have to do that. Now, I would ask, if you've made it this far, for you to do something for me. Help me out by not only sharing this video with anyone you think would benefit from seeing it, but also tell me if you would like to see more content, for example, model answers written for some of these debriefs, or any other kind of content, because I will not start a Patreon channel unless I know that there's interest in that. And finally, you can find much more content in our Power Law program, which I will link below. You'll find not only debriefs, but also model answers to past hypotheticals. And in Power Law Pro, you will also find the unfolding schemas that you see me use in these debriefs. That's a software platform that we developed with a coding partner. So I can't provide that for free, but we do provide it at pretty low cost. Link below.